So I wanted to go over a couple of things. And it's three ideas to think about. One is that contracts is strategic. I think in a way that perhaps crim and torts aren't. Property is, civ pro is, con law is more. There's strategy, there are things that people want, and there's strategy kind of across the board. Contracts and civ pro, I think, give you a lot more work. Contracts, at least in trying to discern, because it's not always super clear, it's not written down what the parties want. They enter agreements, they have a shop, they have a business, and you have this general sense of what they want. But the specific thing that they want from litigation tends to be somewhat less clear than it is in torts or crim. And even in civ pro, there's a lot of strategy to kind of lay out and figure out. But usually, especially if there's some underlying claim, and they generally try to make it clear what it is that that party wants, so that you can see the procedural devices they would use to get that or to block liability. So contracts, the parties seem to have these general desires, but they need to be unpacked a little bit. So one of the critical questions that you have to repeatedly ask yourself in the planning phase of a contracts exam is, what is it that the parties want? That doesn't necessarily even mean generally. It can be kind of a list of different things based on the different tools that are available to them. But you have to focus really hard on what it is they want. That gets translated into contract language. Starting from formation, do they want to even argue that there was a contract in the first place? Sometimes you get cases, and I'm thinking of a recent exam that I graded, where in fact both parties did want the contract to be binding, but they wanted different prices. So that affected the different kinds of arguments that were made, even though you might have various tools at your disposal. Some of them may be self-sabotaging if you want certain things, such as the enforcement of the contract. So you have to think carefully about strategy and what it is that the parties want. Contracts is also specific in the sense that they're often filled with dates and numbers, and they all mean something. And some of you, in kind of going with the general advice to be more nitpicky, kind of disregarded some of the numbers, some of the dates, to not entirely, but weren't as completely attentive to them as you could be. When a number's written down or when a date's written down, it's a very strong signifier that that itself is an important fact. The other thing is that contracts has patterns. There are kind of things that happen in contract worlds that otherwise, this is why lawyers have a dim view of life, is you see when things kind of go wrong. You don't see maybe the 95% of the time that contracts are followed, or that maybe breach happens, but people work it out. So there are specific things that happen. So let me dig a little bit deeper on each of these. So I think I said a lot of this already, but contracts is quite strategic. Torts involves discrete injuries that usually it's very hard to identify claims if you can't identify the injury. So it's much more clear what parties want or what they would try to do to recover. As I said before, contracts can be quite a bit less clear on what the parties want. You just know the contract embeds certain interests of the parties, but what it is that they hope to accomplish is sometimes a little bit less clear. It doesn't speak for itself on the face of the contract. And so it's super important to figure this out in figuring out a claim. I'm still on this point. the easiest way to focus on this is, again, what do the parties want? And so I had the sense with a lot of the exams, and again, this isn't fair, this is just my impression of what I saw. And again, there are probably complicated reasons why people wrote kind of as they did. But I had a sense that too many exams really rushed to apply the law, to show some kind of demonstration that you know how different contracts doctrines worked, without thinking through really clearly why the parties would want to make such arguments. Um, and you can only really be clear on something like strategy if you know what the parties want. So I'm making it a new rule with an arbitrary amount of time. You must think about this for 6 minutes in planning. I'm trying to think. There is an example. I forgot about that. What exactly does X want? What does X want the contract enforced or not? And based on this underlying desire, what can X argue to get what he wants? So there's an example in a hypo recently. I'm trying to remember. It doesn't matter whose, but not every doctrine's usable depending on what it is that you want. So A wants to enforce a contract at a low price. B wants to enforce it at a high price. And I remember one student uh, argued mutual mistake, which is something that the professor hadn't noticed. But I think in this context, it was a creative spotting of an issue. The problem was in this context where A actually wants to enforce a contract, mutual mistake as to a material term can blow up the contract such that A is not able to enforce the contract at a low price. And in this case, if I remember the facts correctly, it's not A would not have been thrilled at all to walk away from the contract because he was in desperate need of the money. I can't remember the exact facts, but this is a pretty concrete example where you have to know that A needs to enforce the contract, and that would force you to the conclusion that mutual mistake is not really a starter here. Now, maybe you can still, even though this is quite a creative use of um, creative identification of mutual mistake, uh, you can say that, you can say just that, mutual mistake is something that A could argue. However, it wouldn't be in his interest because it'll blow up the contract and he wants to enforce the contract on its terms. That'll get you points, I think. Contracts, as I said, as specific dates and prices mean a lot. Dates are facts that are relevant to formation. Was an offer accepted or not? There's the mailbox rule, blah, blah, blah. And it hints at breaches, whether someone missing an L in installment, misses an installment payment on a contract that requires that. And I've had a couple cases in my practice where that was the breach. Prices hint at calculations for damages. And one thing that I would really urge you to do is to not only discuss damages theories after you've determined breach, or you've at least determined that someone can colorably raise breach, such that in the alternative you go through the damages analysis to get more points. You talk about the damages theory, but if there are prices given, you try to actually calculate the damages. And I noticed some exams where people didn't do that. They talked about expectation damages and consequential damages, but if there are numbers, the professor wants an actual number. There is probably a right answer in a way that is less true of other situations. Here's the last thing I wanted to mention about contracts is there are some patterns that you can discern. Now, there's a huge array of different contracts, kind of fact patterns. But the thing to realize is these are mostly zero-sum situations. And one thing to do is to go through your outline and think about in advance, you can't kind of write out answers in advance, but you can begin to plan out different scenarios in your head. So a classic contracts case is someone agrees to deliver some commodity um, at a certain price, and that person actually has to purchase the commodity. Or you've got apples at $10 an apple. I bought some Honeycrisp apples and they were startlingly expensive the other day. But if there's a sudden price swing, someone's stuck with a contract and someone's thrilled to have the contract. So if apple prices go up to $20, the person trying to sell the apples is absolutely thrilled. And the person who has to buy the apples is outraged because, it's the other way around. The person who has to buy the apples is thrilled because they got out of having to pay $20, and the person selling is ripshit because they could have made $20 selling to somebody else. So this is kind of a classic case for when someone is selling commodities, something where there's a market price for something and it kind of fluctuates. Unexpected factual changes usually benefits one person, hurts another. The parties are relying on some law to be a certain way, or that's an implied term of the contract and it changes, so you determine whether or not it's material. But again, the unexpected change in fact will really benefit one side and not help the other side at all. Ambiguity in a contractual term could be insufficiently, or something that's insufficiently specific. I'm not sure why this is hinted deadlines to accept offers. And then parole evidence. This always benefits somebody and not the other party. So these things are all zero sum. And parole evidence being someone says something before the contract closes. What that person said doesn't end up in the contract. And the question is whether or not parole, I suppose the parole comes from French, the parler, parole, spoken evidence, whether that can be understood to be part of the party's agreement or not. Usually some kind of contractual ambiguity is required, and then you can introduce parole evidence. The key there, again, is that someone wants that evidence introduced and the other party very much does not want that introduced. So think about, go over your outline and at least think about previous situations that kind of fall in. This is not a full encyclopedia of different patterns, but this can help you.